All right, good afternoon, everybody. We will give just a minute or so for anyone who's logging on now or being let in from the wait room. But as you know, today's presentation is on new legal requirements for schools in Wisconsin. This is an update on some laws that were passed just recently. Likely a lot of you have legal counsel who should be updating you on this as well to make sure that you're in compliance. But we wanted to offer this webinar as a resource to let you all know which laws were passed, where are they in the law, what do they say, what do they require, when do you need to be in compliance or have a policy to indicate that you're in compliance with them, and give you a chance to ask any questions. So the three model policies that we're going to be going over today are the issue on the cell phones in schools, which is 2025 Wisconsin Act 42. The second one is related to sexual misconduct parent notification. What does that mean? When do parents need to get notified? What does it mean for your school district? That's 2025 Wisconsin Act 57. And the third one is been referred to as anti-grooming bill or having anti-grooming protection. So it governs communications with students, and we'll go over the details of that as well. That is 2025 Wisconsin Act 89. And the way we have this set up today is Lauren's going to go through each of those new laws. And then in between those new laws, I am going to just briefly talk about Will's model policies that we drafted for you all to help you ensure that you are in compliance with those laws. And Lauren, if you want to go back just one slide, I see a few new names on our attendee list today. Just for anyone who is not familiar with Will, we're a nonprofit law and policy center. We're based in Milwaukee, Wisconsin, but we do law and policy work all over the country. And we do a lot of work related to education, litigation, participation in public discourse, advancing limited government, free speech, transparency, and education reform. And this webinar is part of our Restoring American Education project. And we really want to hear from you all. What can we do to be a resource for you? What kinds of questions do you have? What are you seeing in your role as board members? And I see a few names on this list too who aren't from Wisconsin. So just be mindful that these are based on Wisconsin laws. However, if your state has a similar law worth looking at, or if even if it doesn't, as long as these things don't conflict with the laws in your state, it's always something that you can look into doing at the local level as a school board. So please reach out to us at any time. Our email addresses are going to be at the end of this presentation, and we're glad to be a resource and continue to provide webinars like this. I know you all can't get enough webinars, but we hope this will be nice and efficient and provide relevant and useful information for you in your roles as school board members. So with that, I'll turn it over to Lauren.
Awesome. All right. We're going to get started today. We're going to kind of go in chronological order here with 2025 Wisconsin Act 42. This is known here in Wisconsin as the cell phone ban. What's interesting about this law is the term cell phone is only used in one of the definitions. It's actually wireless communication devices. But I wanted to kind of start off each of these laws with the message that the governor gave when he signed this into law. So, what was so important about this that Republicans and Democrats were able to come together, pass this law, and get it signed by a Democratic governor? So, Governor Evers said that he's concerned about the impacts of cell phone and social media use and what they're doing to our children in our state. And that it's tough to be a kid these days. Cell phones can be a major distraction from learning, a source of bullying, and a barrier to our kids' important work of just being a kid. So this actually is very much in line with a lot of studies that we've been seeing in recent years that have been coming out that talk about screen time and cell phone use, particularly in the classroom or in the school. So, as Cory mentioned, I'm going to go over what this law actually says so that you, as school board members, are able to know exactly what you're looking at when you're looking at this statute. So, on the screen here, we have all of the requirements for what needs to be adopted. So, by July 1st, 2026, school boards must adopt a wireless communication device policy that prohibits pupils from using a wireless communication device other than a school-issued wireless communication device during instructional time. The school board may include in the policy consequences for violating the policy, and nothing in this law says that schools can't adopt stricter policies than what is required by law. So schools can always take it further than what the statute is saying, but this is the very bare minimum requirement. Schools have to, by July 1st, 2026, adopt a policy prohibiting students from using wireless communication devices during instructional time. So, thankfully, the statute actually does define what a wireless communication device is. The statute specifically says that a wireless communication device means a portable wireless device that has the capability to provide voice messaging or other data communication between two or more parties and includes all of the following. So, these four things have to be included in terms of being a wireless communication device: a cell phone, a tablet computer, a laptop computer, or a gaming device. So all of those things are very specifically wireless communication devices. There may be things that fall into that category that the school can prohibit additionally. But those are the four main things that the statute absolutely requires to be considered a wireless communication device. The statute also requires that there be exceptions to this prohibition. So, in the event of a perceived emergency or threat, for example, if there was a crisis in the classroom, a child would be able to call 911. To manage a student's health care, if a student needs access to a phone or something that the school would consider a wireless device, but they need it for whatever their health issue is, that's something that needs to be considered as an exception. Use in a student's IEP or 504 plan, that's something that can be built into their plan specifically, and that can be an exception to this prohibition. And then authorized use by a teacher for educational purposes during instructional time. It's been a couple years since I've been in high school, but I do vaguely remember every so often answering a question on my phone. That's something that would still be allowed under this statute, even though schools have to prohibit personal use of cell phones or wireless communication devices during class time. And then there's also a reporting requirement under the statute that says that by no later than October 1st, 2027, and each October 1st thereafter, schools are required to notify the Department of Public Instruction of whether changes were made to the policy submitted under this paragraph in the previous school year, and if changes were made, to submit that updated policy. So you'll have to provide the DPI with your cell phone policy. And then if any changes are made to that cell phone policy, you'll have to submit that new policy to the Department of Public Instruction by October 1st each year. So with that, I'm going to give it back over to Cory to talk about what's included in our model policy for wireless communication devices.
Yes, thank you, Lauren. And I am guessing many of your school districts already have some version of this in place. So I'll be rather brief. We start all of our model policies with why adopt this. Obviously, here now in Wisconsin, we have a law that requires it. So that's number one. But also eliminating personal devices from the classroom fosters more meaningful face-to-face interactions among students, creates an environment that prioritizes academic engagement and supports overall student well-being. And there's a lot of studies out there now that show a benefit of this, and many states are passing similar laws. So our policy then is intended to achieve that goal and help you comply with the new law. And one thing we start this particular model policy with is definitions, just for clarity. Um, what is an emergency? Lauren mentioned there's an exception for an emergency. So, for example, we define it means a situation that poses an immediate threat to the safety, health, or well-being of individuals on school grounds or during school-sponsored activities, and where use of a wireless communication device is necessary to seek assistance, report an emergency, or communicate urgent information to authorities or designated personnel. We define instructional time, uh, who a parent is, because that we'll get to that at the end of the policy. What are school hours? It might seem common sense, but just so that everybody's on the same page, what are we considering to be school hours? When does this apply? And then, as you can see here, wireless communication device. What does that mean? It includes obviously a cell phone, tablet, laptop, gaming device, as is included in the statute. What about smartwatches, GPS watches, other wearable devices? Our policy indicates those may be worn, but only if wireless communication capabilities like voice calls, messaging, those should be disabled during instructional time. So we include some details for that as well. And then in terms of the scope of the policy, our model policy indicates that the use of wireless communication devices during instructional time is strictly prohibited. You could even make that stronger and have it be a bell to bell. That's actually what we would recommend, well, I would recommend. I think even within Will, there's some disagreement about how often can the students access in between classes, during lunch, during homeroom? So that's a decision that you'll have to make. But if you wanted to make it stronger, and I'm seeing a lot of schools go this route, have the student put it away in the morning, they get it back at 3 or 3:30 at the end of the school day. Um, and require the students to stow those devices, designate the location. That way they do not have them at a minimum during instructional time. So I know there's pouches you can get for this, a cell phone cabinet. You could even just have a basket. I've heard of students bringing old phones or burner phones. So like this is something just to be mindful about and let your teachers know and support them as they try to enforce this. I think that's key is giving teachers the support to enforce this. And also now having a state law and having a school board policy is going to help them very, very much because they don't have to be the bad guy. This is required, and it should be enforced strictly. We have some exceptions included, and then we have enforcement. Just so again, everybody's on the same page. What happens if a student is caught with a cell phone during instructional time? You should have a disciplinary action, and our recommendation is to have that be progressive, depending on the number of violations, and it can involve one or more of the following. And again, I've seen schools where if they enforce this all the time, consistently, every time, that is going to help in the long run. So confiscate the device until the end of class, confiscate the device until the end of the school day, hold it to be picked up for a parent if needed. Perhaps the student will lose privileges, detention, suspension, and then just a few other details in here about if the device is confiscated, how is it going to be returned? School officials will not search or otherwise manipulate the devices unless, and then we have some very specific criteria here. For example, there's an immediate threat to the safety and security of students, staff, or school property, such as threats or acts of violence, and a few other examples there. But other than those, the school officials shouldn't be manipulating or searching the device. And just ensuring that school administration lets parents know of any important updates or incidents involving their child, encouraging a collaborative approach to student safety and well-being. And that brings us to the last point on this one. Parents. In talking to schools and talking to parents, parents are actually the biggest roadblock a lot of times with implementing a policy like this they've grown used to being able to contact their child throughout the school day, and they don't like not being able to instantly access their child. But I think once this is in place, once parents get used to it, they know they can call the office. You should have a policy if they do need to reach their child. How are they going to do that? They can call the office if there's something they need to share. Um, but what we recommend, and this part isn't in the law, but we would recommend annual notice to parents. Give them an update on this policy. Tell the parents how they can maintain communication with their child during the school day through school channels. And then we also recommend a device agreement for parents and students to know the expectations and consequences related to this wireless communication device use at school. They will be asked to sign an agreement, which includes the information contained in this policy, as well as an explanation, and it doesn't have to be long, about the detrimental impact of excessive cell phone use. Parents and or students, if they don't sign, because realistically, sometimes you might have parents that are unwilling or they just don't get to it and they don't sign. It just indicates that that doesn't impact the enforceability of the policy, but just trying as best as you can to explain why this is a good policy, why it's in place, how it's going to be enforced, and get everybody on the same page. And then at the end, there's a legal analysis. So we would love it if you would either adopt this version or just use it to compare to what you actually have and see if there's anything that you might be able to strengthen or revise or edit to what is currently in place. Eric shared a link to this in the chat, and all of these are also available at schoolboardpolicies.org. So if you have any questions, feel free to put them in the Q&A function or the chat. I don't know what we have in this one, but we will be monitoring those and take those at the end, and we will move on to the next one.
Have to unmute myself. So, the next one that we're going to talk about is admittedly what I think is the most complicated of the three. So I want to make sure that as we're going through the law section in particular, that I'm really hitting all of the major requirements here. As Cory mentioned, please, as we're going, feel free to drop questions in the chat and we'll address them at the end. But Act 57 was adopted in December of this year. This is a requirement that doesn't say that school boards need to adopt a policy on how to handle this, but it does have very specific requirements with very fast turnaround times that we believe would be best handled by preemptively adopting a policy so that your staff and your school community knows what to do in situations as they occur. So 2025 Act 57 deals with parent notification of alleged sexual misconduct. When adopting this law, Governor Evers said that doing everything that we can to keep our kids safe at school, at home, and in our communities is a top priority for me, as well as our schools and educational professionals who are on the front line doing what's best for kids every day. Um, Gotta go back this way. Okay. So most of the law, Act 57, is contained in this one sentence. You'll see some ellipses in here. That's just going through its school boards and charter schools and private schools. So it's not substantive, but it says that each school board shall, after receiving a report that alleges any of the following, notify the parent or guardian of each pupil alleged to be a victim, target, or recipient of the alleged conduct of the individual who received the report determines there is reasonable cause to suspect that the alleged conduct occurred. So I'm going to kind of go line by line and break this down. I feel like that's just the easiest way to kind of go through this. And the first thing that I'll talk about here is what is any of the following? In the statute, when you're looking at it, you can go to that section and read through it. But it really breaks down to three different things: sexual misconduct by a school staff member, a conviction of a serious child sex offense by a school staff member or volunteer that requires the individual to work or interact primarily and directly with children in a manner that would be a felony, And three, a sex offender has captured a representation of a minor pupil. So anytime that the school board receives a report of any of those things, that's when this statute is triggered. So, if an individual who received a report, who are we talking about here? Is it just anybody at the school that can receive these reports? Specifically, the statute gives two people or two groups of people that are able to receive these types of reports. And a report is considered to be received by a school board when it's received by an individual employed by the school district and either of the following apply. So, one, for purposes of employment, the individual is required to hold a license issued by the department under certain Wisconsin administrative code sections. These two administrative code sections are for district administrators and principals. So, if they receive a report, the report is considered quote unquote received. And then the second category is the people who have been designated as a Title IX coordinator. Will did quite a few webinars back last summer or 2 summers ago on Title IX and the Title IX requirements. So we have some additional information on that if you're looking for it. But those are the two categories of people for school boards and school districts to receive these types of reports. So this individual then needs to make a determination about whether or not there is reasonable cause to suspect that the alleged conduct occurs. Reasonable cause is not defined by the statute, which makes it a little bit tricky for schools because there's some discretion that's involved here. So, what does it mean to have reasonable cause to suspect? It likely means, we don't know for sure, again, there's not a definition, but it likely means that a prudent person would, given the totality of facts and circumstances actually known to that person, suspect that the alleged conduct occurred. So again, a little bit tricky. There's not a ton of guidance in the statute on this piece, but if those individuals who receive a report, given all of the facts and information that they have available to them at the time, suspect that that alleged conduct did in fact occur, then they have reasonable cause to suspect in this scenario. Okay, so a school receives a report. We know what the report needs to be about. We know who needs to receive it. We know what the individual needs to determine in order to get to this next step, which is notification of parents. So each school board, after receiving a report of any of the following, must notify parents or guardians of each pupil alleged to be the victim, target, or recipient of the alleged conduct. So this is the hardest part for schools to have to address here because there are very tight timelines for parent notification under this law. So if there is reasonable cause to suspect the report was received, it is conduct that is covered by this law, then notice has to be provided either in person or by phone. By phone does include voicemail if you're unable to actually get a hold of the parent. And it has to be by no later than the following two options, whichever is applicable. If the report is received on a school day, the parents have to be notified before the end of the regularly scheduled day of instruction, or 5 p.m. that day. Or if the report is received on a school day, after the end of regularly scheduled instruction or on a day that's not a school day by noon of the next calendar day. And they say calendar very specifically in the statute, so they're not talking about school days. If a report is made after instructional time ends on Friday, then that notification needs to be made by noon on Saturday. Or if you're on Christmas break and something happens, you receive a report, that needs to be noon of the next calendar day. So very, very tight timelines. As I mentioned, this is why we think it's really important for schools to be aware of what these requirements are and have a plan of how to notify parents ahead of time before these things happen. Because to be in compliance with this law, there is very, very specific timelines here. There's only one other provision that I wanted to touch on very briefly, and that is that school boards have to annually provide parents and guardians with information regarding their rights to access records regarding school employee discipline under Wisconsin's open records laws. So this is something that's new for schools this year. And essentially, you just have to provide parents with a way, if a report is made, they're notified under this statute. Parents typically are going to want additional information on what's being done. And therefore, the statute is requiring that school boards tell parents what the next step is in accessing records and as it pertains to employee discipline records. So I know that that was a lot. This is a complicated, again, of the three, this is the most complicated law. So with that, I'm going to turn it back over to Cory to go over our model policy that hopefully helps smooth things over and make things a little more clear here.
Yes, thank you, Lauren. And we'll be going over a lot of that again. I think it's sometimes helpful to hear these things twice to get a handle on what is being required. Again, this policy starts with why adopt it. Again, state law requires it. It creates this new parental reporting requirement for schools relating to incidents where students are the victims of certain sexual misconduct by a school staff member or volunteer. So that's the goal here. If something might have happened, how are we going to make sure parents are involved and notified? And the idea behind the policy is you want to have a clear, consistent practice to comply with the requirements in the law. And we think that by proactively implementing this framework aligned with the law, school districts can then strengthen transparency with parents, reinforce student safety, and institutional accountability. And then this model policy also helps districts demonstrate good faith compliance and preparedness if questions arise. It's always good to have something to go back to. And I'll mention a little bit later too, but nothing here. You might be familiar with mandatory reporting laws and wonder, how is this different? What does this mean for mandatory reporting? Nothing here is intended to conflict with existing mandatory reporting laws. All right. And after that, so in this one, we put the definitions at the end of the model policy. And the primary reason for that is because they're long. We were thinking of just cross-referencing some of this, but I think it's good to have it all in one place. Like there's this language about captures or representation. What does that mean? Well, it means to take a photograph, a motion picture, videotape, recording, other visual or audio representation, something that represents a visual image. Now, the longest part here is, what does it mean for an individual to be convicted of a serious child sex crime? And this one is long, but we put it all in the model policy so that in the event you need to look into this, it's right there. A person who alleges to be a therapist intentionally has sexual conduct with a person who at the time was a minor patient or client, a person who has sexual contact or sexual intercourse with someone who was a minor at the time of the offense and suffers from mental illness or deficiency. There's a number of, again, serious, as is in the phrase that we're defining, but what exactly does that mean? Where is it in the law? It's all right there in our model policy for you to refer to. The next step, then, if there is an allegation or a concern about sexual misconduct against a student, who's receiving those reports? And Lauren went over this, but what we did in our model policy is indicate report designees. So you can change that if you want to, but here it says any licensed principal or district administrator or the individual who has been designated by the board to be the Title IX coordinator as defined in federal law, those are your report designees. And if any school staff member receives or becomes aware of an incident that should be submitted to a report designee, that staff member has to forward all information in their possession to the report designee as soon as practicable and no later than Here's where we're getting into the deadlines that Lauren was mentioning. No later than one school day after the governing body or staff member sees or becomes aware of the report. There, we have an asterisk on our slide. We think this is a best practice. It's not explicitly required by the new law. And the next step then is, okay, you made a report. Now what? What is the evaluation process? So what we have indicated here is a report designee shall first determine whether the report alleges any of the following. Did it allege sexual misconduct by a district staff member or volunteer? Did it allege a conviction of a serious child sex offense by the district staff member or volunteer? Did it allege a sex offender has captured a representation of a minor pupil? If none of those above situations are alleged in the report, then the report designee shall follow the procedures described at the end of this policy in a section reports of conduct not covered by this policy. If one or more of those situations are alleged, then the report designee, based on the facts alleged in the report and the totality of the facts and circumstances actually known to the report designee, then they determine whether there's reasonable cause to suspect that the alleged conduct occurred. If the report designee thinks yes, there is reasonable cause to suspect that the alleged conduct occurred that meets those criteria, one or more of those criteria, then the report designee shall notify the parents of each pupil alleged to be the victim, target, or recipient of the alleged conduct by speaking to them in person or by phone within the timeline set forth in the parental notification section. If they think no, there's not reasonable cause to suspect the alleged conduct occurred, immediate parent or guardian notification under this policy is not required, but it is the policy of this school that the report shall be reviewed further and additional steps may be taken as appropriate. So just because there's not a action being triggered by this policy or by this law, that doesn't mean you should stop looking into it. So we just think that's a best practice as well. And this just kind of goes over what I just described. So uh, can you go back one and show how our model policy, okay, we make two specific changes to slightly broaden the scope of those categories. Sexual misconduct by staff, that's required by law, and ours includes volunteers. It's not required for sexual misconduct, but it is required for that other category of conviction of a serious sex crime. So we broadened it slightly. And then it does not specifically include or exclude reports of conduct committed by the student's parents. All right, and then moving on to parent notification. If a report designee receives a report of conduct covered by this policy and has reasonable cause to believe that the alleged conduct occurred based on that report, he or she must notify the parents of each student alleged to be a victim, target, or recipient of the conduct. And this kind of, I don't need to read all of it. This is what Lauren was saying. If the report's received on a school day before the end of regular scheduled instruction, the report designee must notify the parents in person or by phone by no later than 5 p.m. that day. If it is received on a school day after the end of regularly scheduled instruction or on a day that is not a school day, then the report designee must notify the parents in person or by phone by no later than noon of the next calendar day. And if a report designee attempts to notify the parent via phone, but the parent doesn't answer, you can leave a voicemail that would satisfy the notification requirement. And what does this notice? The next question just in this section is what does this notice have to include? What should it include? This is not something that's explicitly required by the new law, but we thought would be useful to have in a policy. And we recommend that the district provides sufficient detail of the report so the parent knows what the allegation made is, a basic explanation of what are the next step the school's planning on taking with the report, and who can the parent contact for updates. So our recommendation is that's the information you want to share when you're giving this notice. All right, and Annual notice. So this again is something that Lauren went over. Our model policy includes it as well. The district should each year on an annual basis provide parents, guardians, school staff, and volunteers with updated contact information for the report designees and post that information. So there's no question about who it is that's going to be receiving these reports if anybody has them. And part of the annual notice, the district shall also inform parents and guardians of their rights to access records related to school employee discipline in accordance with. We cite Wisconsin statutes starting at 19.31. That's our open records law. And we just indicate here that if the board adopts a uniform report document to be used, then that document should also be included in the annual notice and posted online and be available and accessible to parents. And what about reports that don't meet those three criteria that I mentioned? Sexual misconduct by a district staff member or volunteer, conviction of a serious child sex offense by a district staff member or volunteer, sex offender has captured a representation of a minor pupil. What if there's maybe still a concern, but it doesn't fall within one of those categories? Again, this is not explicitly required by the new law, but it fits very closely. So we thought it made sense to have in the model policy. And our recommendation is that if the situation or incident could trigger the mandated reporting requirement under Wisconsin Chapter 48, then the report designee must follow the mandated reporter procedure described by statute. If the report designee receives a report that does not allege conduct that triggers this policy, nor does the conduct trigger mandated reporting requirements, then the school should have an internal investigation procedure for employer volunteer misconduct, and the report designee should follow that process. Oh, and before we move on, I just wanted to mention one thing in the legal analysis of this one. We cited a case called Garrity, referred to as the Garrity principle. So it's at the end of this model policy, and it says when a school district conducts an investigation, it cannot force an employee to give up the Fifth Amendment right against self-incrimination by threatening termination. So school district employees or volunteers, they can assert their Fifth Amendment rights in response to specific questions that present a genuine risk of self-incrimination. So just something to be mindful about. Ask your district legal counsel if you have any specific questions related to the Garrity principle.
All right. So I know that was a lot. We threw a lot at you, but that's the overview of Act 57. And we're going to move on to Act 89, which is a little bit more simple in some ways. In other ways, there's more discretion that school boards have, which some school boards like because it means more flexibility for them, and some school boards don't want to have to come up with all of that language on their own. So kind of pick your poison here. But 2025 Wisconsin Act 89 is commonly referred to as the anti-grooming bill. And this is what our governor said when adopting this bill. Keeping our kids safe, especially while they're at schools, is a top priority. We have an important obligation to make sure our kids feel safe, secure, supported, and cared for by educators and staff in our schools. Adults they should be able to trust and depend on, while also providing more clarity about what interactions with students are inappropriate and unacceptable, and enhancing punishments for adults that violate that sacred trust. So, what does Act 89 actually require? By September 1st, 2026, each school board shall adopt a policy on appropriate communication between an employee or volunteer when acting in the individual's official capacity and pupils. So, the whole crux of this requirement is communications between school employees and volunteers and students. And then annually, this is the second part, second big requirement under this law. Beginning this coming school year, each school board must provide to its employees training in identifying, preventing, and reporting grooming and professional boundary violations. So those are the two big requirements under this law. You need a new policy by September 1, and you need to start additional training starting this next school year. So let's talk a little bit further about what's required under this law. It specifically talks about communications between employees and volunteers and students, but they have some pretty specific language in here when acting in their official capacity. What does that mean? Not defined under statute, but there is a lot of case law in Wisconsin that does talk about official capacity. It's going to be a fact-based analysis that schools will have to make, likely in tandem with their school attorneys. But in general, what it means to be acting in your official capacity is whether or not um, an employee was at least partially actuated by a purpose to serve the employer. So you're doing something to help the employer. I have a couple cases on the screen if anybody's interested in where I'm getting some of that language from. Neither of these cases specifically have to do with schools. But we're talking about what does it mean to be acting in an official capacity. This is logic that could be applied in a school setting. So again, it's going to be that fact-based analysis. When something happens, the school's going to have to figure out, okay, was this employee acting in their official capacity? Was this volunteer acting in their official capacity? Or were they doing something so outside the scope, it had nothing to do with the school, that this policy wouldn't apply? There we go. Okay. So there's three things in particular that the statute requires for schools to include in this policy that they have to adopt by September 1st. First, standards for what is appropriate content of communications that occur during or outside of school hours. Standards of what are appropriate methods of communication that occur during or outside of school hours, and a range of consequences, the most serious of which is termination for employees or volunteers who violate this policy. So those are the three big things that schools need to include in this policy. But what appropriate content is, what appropriate methods are, those are things that will be up to your board to decide. Okay, and then I also just briefly wanted to go over this training requirement because it's a little more complicated than just providing a training. They talk about what needs to be included and then some options for training. So, as I already mentioned, annually, beginning this coming school year, 2026-27, each school board shall provide to its employees training in identifying, preventing, and reporting grooming and professional boundary violations. The Department of Public Instruction is required under this new law to develop and make available to schools at no cost this training. So the DPI, sometime within this next year, we don't have a specific timeline on that. Obviously, we're not affiliated with the department, so we don't know exactly where that training is at this point. But they are required under this new statute to develop and make available to public schools and private schools at no cost this training. Schools, however, don't have to use the DPI training if they don't want to. A school board may provide to its employees the training developed by the department or a different training that the governing body of a private school, a charter school, or a school board determines is sufficient to ensure compliance with its policy. So if you're going to do a training that is outside of the DPI's training, you'll have to make sure that it meets those couple key features. So identifying and preventing and reporting grooming, professional boundary violations, and then compliance with your policy. So those are the requirements for the training here. And with that, I will turn it back over to Cory to talk about what our model policy includes.
All right, I will try to go through this one rather quickly in case we have any questions. Just a reminder to use the Q&A function. Um, why adopt this policy? Obviously, we don't want grooming to be happening in our schools. So having a clear policy, a comprehensive policy, obviously you need it to comply with this new law and also to protect students. You want to protect staff, you want to protect the school community. So this model policy is designed to help you meet those requirements and have a policy that's workable for everybody. And the first thing in this policy that we start out with after the purpose is the scope. So this policy applies to any communications between an employer volunteer when acting in their official capacity and all students. An employer volunteer is acting in their official capacity when their actions are at least partly motivated by doing their job or helping their employer, as Lauren said. What is all students? This is not specifically addressed by statute, but we think it may still be required, and we've included in our draft model policy here. The term all students includes students currently enrolled in the district, students who do not attend the district or are homeschooled. So maybe they play on a district sports team or they come for an extracurricular. Maybe they're playing on district property and they interact with a teacher. It also applies to former students, so maybe they switched schools, maybe they haven't graduated high school yet, but they're not 18 yet. They're not 18 years or older. Even if they don't still attend the district, still applies with communications to those students. Applies to communications that occur during or outside of school hours and include all methods of communication, including electronically. And then we included here, obviously the statute requires that boards of policy with standards and methods for appropriate communication. So what's the content and what are the methods? As Lauren mentioned, the schools have quite a bit of discretion here. What we recommend and what we have in our model policy is that the communication must be this and it cannot be this. So what must it be? It must be professional in tone, appropriate for an adult-student relationship. It must relate to legitimate educational, extracurricular, safety, or school-related purposes. It must avoid any personal or intimate details about the employee or volunteer's life. We understand that sometimes students will share intimate or personal details about their own life with staff at school. That's not unexpected. That's not prohibited by this law or policy, but what we think is more inappropriate and what we want to avoid is the adult, the employee or volunteer sharing personal or intimate details about their own life with a minor student. And it also must not encourage students to keep these communications or their contents a secret. And then what do we want to avoid here? We want to avoid communications, obviously, that are sexual, suggestive, or romantic in nature, encourage a student to keep secrets from their parents or other school staff, discussing personal matters about the employee or volunteer that don't serve any legitimate school purpose in a manner that blurs professional boundaries. And we've included a few other details as well. We don't want conduct or communication that's commonly associated with grooming behavior. Obviously, this has been referred to as the anti-grooming bill. So what does that include? You don't want staff attempting to build an inappropriate personal relationship with a student, isolate a student from their parents, seek secrecy in communications, giving personal or excessive gifts to a student outside of approved school activities, or gradually introducing increasingly personal or boundary crossing conversations. So that's what we have indicated in the standards, the content for appropriate communication. The next thing is methods of communication. Again, this is something you'll have to think through for your specific school district, but we want there to be a framework here. The law requires a framework here. What is an acceptable communication method? Our model policy recommends school email accounts. If you use a school learning management system like Canvas or PowerSchool, if your district uses an app like Class Dojo, Student Square, School Messenger, other communication tools authorized by the board or district administration for educational or extracurricular purposes, those are all appropriate in our view. Our model policy asks employees and volunteers to avoid private one-on-one electronic communication with students unless necessary for legitimate school purposes and consistent with district policies and guidelines, and indicates that any communication with a student should be transparent. It should include a parent as a recipient or at least be conducted in a way that parents can review or access the communication. So that language can be adjusted in a way that fits your district needs. The last few sections here, we recommend keeping the records. You don't want staff having private communications with students and then deleting those. So if there is a scenario where communication needs to be reviewed, those aren't being deleted and lost. So all communication should be retained in a way to ensure transparency and accountability. What about concerns? Any person who becomes aware of communication that could violate this policy should report that concern to the school principal or an individual designated by the school principal. And these two sections here on record keeping and reporting concerns, these are not specifically required by the state statute, but how to report concerns is obviously something that is required in the annual training. So we think it might as well be included. Next, investigation and consequences. The statute requires that boards adopt a policy with a range of consequences. What those consequences should be is up to the board. What we recommend is, first of all, how do you investigate? You're going to designate someone to retrieve and review the communications at issue, talk with the employer or volunteer who may have violated the policy, notify the parents of any implicated students, talk with the student and his or her parents, and if applicable, we've just cited here the mandatory reporting statute and the Act 57 statute. So if it's a situation, if it's an incident that triggers one of those other laws, just to be mindful of that, to follow that process as well. And if an investigation has been conducted, the principal or designee determines there has been a violation of the policy, the board or the administration should determine appropriate consequences, and they may include but are not limited to, this is what we recommend, a verbal or written warning, required training or corrective action, suspension or administrative leave, removal from volunteer service, termination of employment, or banishment from school property. Now, turning to the second to last section, this is about the training. The training is required by statute. It can either be from DPI, which is not yet ready, but will be. DPI is going, as we mentioned, has to offer this training, or it can be based on your own policy as long as you satisfy the requirements in the statute. You don't have to train volunteers, but our recommendation is to provide them. Make sure they all have a copy of this policy and are given a chance to answer any questions. And if you're not going to follow the DPI's training, what does it have to include? It's these 5 bullet points on your screen taken directly from the new law. The appropriate standards and methods of communicating, identifying unprofessional and inappropriate behavior. So how are you going to spot it? What is unprofessional and inappropriate? Preventing professional boundary violations, reporting suspected misconduct, and then any changes or additions to the policy. What we don't want to have happen is for your staff or volunteers to say, well, I didn't know there was this new policy, or I didn't know I was subject to this. I didn't know the district passed a new policy about how we can and can't and should and shouldn't communicate with students. You certainly want to make sure that your employees in your district are aware. They know the standards, the methods, how to identify, what to do if there's a concern. And that's really the intent of the training, is that they understand the new law, the new policy, and what is required of them. And the last section, again, not required by statute, but makes sense. We want employees and volunteers to be informed about the policy and how is it being carried out. Do you want to designate the principal or have the principal designate another individual? How are we going to carry this out? So we recommend that we have a principal or they can designate someone, should implement procedures consistent with this policy just to ensure that employees and volunteers are informed of its requirements. All right. That is all we have, unless Lauren, you have any. I don't actually see any questions. If anyone comes up with anything, I know this happens a lot. You might run into something in your district or you think of something after the presentation. Feel free to reach out to us, or feel free to, we have a few minutes here to put it in the Q&A now. And we would be happy to address any questions or if there's anything we can clarify. I know that was a lot of information, but we're really glad you're joined to learn more about these new laws and what you can do as board members to ensure your district is in compliance.
Yeah, we'll hang out here for just a second in case anybody does have questions. But in the meantime, I'm also going to put up our contact information on the screen so that you can contact us if something comes up or you think of something. If you're joining us on Facebook or any other live stream other than the Zoom, we unfortunately cannot see your questions. And it's a good reminder to register for our webinars so that if you do have questions, you're able to ask them. Okay, we have a training requirement question. Will all the new requirements come with the DPI recommendations, or will districts have to create their own trainings? So there's two options for schools. You either get to participate in the DPI's provided trainings. We don't know exactly what that looks like yet, except that under statute, and we kind of went over this, there are specific requirements for what needs to be included in that training. We don't know if DPI will go beyond those requirements or what exactly will be included in that training. But the other option is for schools to provide their own training. That's something that they can either contract out for or something that they can do in-house on their own if they want to, just so long as it meets those standards under the statute that Cory and I went over during the presentation. All right.
All right. Well, as we said, feel free to reach out at any time. We're happy to be a resource. You can and should also ask your legal counsel for your district about these new requirements and crafting policies to comply. And then the last thing is we really do take your feedback if you want to hear about a particular topic or a new court decision or something that's coming up in the classrooms. If you want to know more, let us know. And sometimes we get questions on the same topic from a number of school board members, sometimes even from different states, and it really helps us direct our resources and dive in and help you all, help support you all and empower you in your roles. So please do let us know. And thank you for joining.
Great.